Article 4 focuses largely on the relationships between states. The full faith and credit clause requires each state to recognize and give effect to the public acts of other states. The Privileges and Immunities Clause of Article 4 forbids states from discriminating against citizens of other states. It is important to note that the words privileges and immunities are also used in the 14th Amendment, but do not share a common meaning. The protections of this clause are available to residents of another state that have been discriminated against, but do not extend to corporations or aliens. In order to show a denial of privileges and immunities, an individual must show that a right fundamental to national unity, such as the right to practice his or her profession, has been denied. Courts have generally used the Privileges and Immunities Clause to vindicate economic rights of out-of-state residents. For example, an Alaskan rule favoring state residents for employment on the oil pipeline was struck down under the Privileges and Immunities Clause. But a Montana provision charging out-of-state hunters higher licensing fees was upheld. If a right is considered protected, courts will strike down acts that discriminate against citizens of other states, unless it can be shown that those citizens are a peculiar source of evil, and there is a substantial relationship between the law and the evil. This means there must be no less discriminatory means of addressing the issue. Section 3 sets out the rules for the entry of new states into the Union, and gives Congress authority over public lands and U.S. territories. Section 4 guarantees every state a republican form of government and protection from invasion and domestic violence. These are obligations of the federal government to provide security and protection for republican principles to each of the states.